Stop. Stop. Listen. Be carefully. A single DUI could erase decades of life built in the United States, even for a lawful permanent resident who has called this country home for 30 years. Tonight on Global Immigration Updates, we unpack what is happening with H.R. 875, what it could mean for you and your family, and exactly what steps you can take today to protect yourself while the law is still in motion. I am David, your guide through the complex landscape of immigration policy, and together we will separate the facts from the fear, the policy from the rumor, and the real consequences from the headlines. Our goal is to provide credible information, practical guidance, and a path to safer decisions for you and your loved ones. If you value straightforward analysis from someone who understands both the human and legal dimensions of these changes, make sure to subscribe to Global Immigration Updates and tap the notification bell so you won't miss the next critical development. We know that for non-citizens living in the United States today, every update can feel urgent and personal. The stakes are high, the timeline is uncertain, and the risk of misunderstanding can carry real implications for families, jobs, housing, and future plans. With that in mind, we begin by laying out the current landscape, the procedural steps a bill like H.R. 875 must navigate, and why the difference between a bill and law matters so profoundly for people who call this country home. Then we will move from the overall framework to the specifics, to what it would change in day-to-day life, and to practical steps you can implement immediately. We will anchor any discussion of changes to official sources, so you can verify what is being proposed, what is already law, and where the process stands at every moment. This is not about sensational headlines or fear-mongering. This is about clarity, accountability, and the protection of you and your family through informed choices. It is essential to treat policy as evolving and to avoid presenting any outcome as guaranteed. It is also crucial to understand that the law often interacts with individual circumstances in subtle ways, and no single story fits every situation. Now, to start with the ground you stand on today, if you are a green card holder, a visa holder, or any non-citizen living in the United States, you should know that H.R. 875 is a bill in Congress that would make significant changes to how immigration authorities assess risk, eligibility, and potential removal. But it is not law yet. The House of Representatives approved the measure by a substantial margin, a sign of political energy behind the proposal. But the Senate has not yet acted, and the White House has publicly indicated support for the concept while leaving room for negotiation and amendment. Let me be precise about the status. H.R. 875, officially titled the Jeremy and Angel C. and Sergeant Brandon Mendoza Protect Our Communities from DUIs Act of 2025, was passed by the House on June 26, 2025, by a vote of 246 to 160. It moved to the Senate the following day, where it was referred to the Senate Judiciary Committee for consideration. This is an important step in the legislative process. It does not become law simply because it has cleared one chamber. The path to enactment includes committee action, a full Senate vote, and if approved there, approval by the President. Without those steps, the measure is not enforceable and cannot change your status today. In this analysis, we will not rely on rumor or crowd chatter. We will rely on official channels and widely used trackers that provide transparency about how a bill moves through Congress, what amendments are offered, and when votes occur. For example, legislative tracking data show that only a minority share of bills that reach committee stage go on to become law. That context matters when people see bold headlines about a new policy. The value of our approach, here on Global Immigration Updates, is to help you understand the process and to highlight concrete actions you can take now to protect yourself while the political process continues to unfold. The current design of H.R. 875 would change two core areas of the Immigration and Nationality Act, which is the central framework governing who can enter the United States and who can stay here and under what conditions. It would amend Section 212 of the Act, which handles inadmissibility, and Section 237, which addresses removability. The most consequential idea in the bill is a new ground for inadmissibility under 212A2J, which would treat a non-citizen who has been convicted of a DUI or who admits to having committed one as inadmissible, meaning that the government could bar entry at the border or accessibility for adjustment of status if you are already living here. In plain terms, this would create a new, broad rule. A first-time DUI, regardless of the severity of the underlying facts, would be treated the same in immigration terms as the most serious offenses. Even more critical is the deportability dimension under a new 237A2G, which would make DUI or DWI offenses a direct ground for deportation, independent of the usual fact patterns and contexts that currently matter in immigration court. The system today weighs factors like aggravation, injury, driving record, rehabilitation, and family ties, and it sometimes uses discretionary judgments to account for the complexity of real life. H.R. 875 would remove that discretion, creating a framework that would treat a simple, first-time DUI the same as a more harmful act. For non-citizens, this matters in every category: green card holders, non-immigrant visa holders such as students or workers, temporary protected status recipients, and others who do not have citizenship. It would also impact long-term residents who have built lives here over decades, not just newcomers. The admission provision is especially troubling because it does not require a formal conviction. It would count admissions of alcohol consumption before driving, or even an admission that you understand what constitutes driving under the influence, as triggers. This is a departure from the normal criminal law framework in which the right to remain silent and the right to counsel play essential roles in many cases. The immigration system uses different standards than the criminal system, and some admissions can have serious consequences even when no crime is proven in court. The existing law already includes some DUI-related immigration consequences, but it recognizes that there is a spectrum of offenses and outcomes. The current framework, with the possibility of discretion, allows for defenses and considerations such as rehabilitation and the passage of time, as well as the effects on families and community ties. H.R. 875 would replace that nuanced approach with a more rigid rule. It would convert a single, non-consequential DUI into an automatic and permanent risk to status with the possibility of removal from the United States. The political dynamics behind H.R. 875 are complex and reflect a broader debate about how to balance public safety with fairness and due process. Supporters argue that the policy would remove individuals who endanger others while visiting or living in the United States from continuing to be in a position to cause harm. They point to tragedies involving non-citizens driving under the influence as grave, preventable harms that should have consequences beyond fines or license suspensions. They emphasize that the policy would hold guests in the United States to clear standards and that deportation is a legitimate tool to deter dangerous conduct. They also note that the bill has drawn bipartisan attention, with support in the House from lawmakers across the political spectrum, yet the opposition raises significant concerns. Critics say the bill is too blunt, treating a range of DUI offenses as identical and failing to distinguish between a first-time, low-risk offense and a catastrophic incident. They worry that this would create a two-tier system of justice in which non-citizens bear sanctions that far exceed those available to citizens for the same conduct. They emphasize that immigration law, historically, has allowed for discretion, humanitarian considerations, and the possibility of waivers in some cases, depending on the facts. They argue that the removal of discretion would risk separating families, cutting off opportunity, and punishing long-time residents who have contributed to the community in substantial ways. Civil rights advocates caution that the bill could interact with existing policing practices in ways that may concentrate enforcement in immigrant communities, raising concerns about due process and equal protection. Constitutional concerns have been raised about the proportionality of deportation in cases that involve a single minor offense that does not involve violence, and there are questions about whether a policy that can banish someone permanently for a single DUI aligns with constitutional protections against arbitrary removal or excessive punishment. In light of these debates, there are concrete steps to take now that reflect prudence and foresight. The first and most important is to protect your own rights when dealing with law enforcement or immigration officials. If you ever find yourself questioned about alcohol use or driving, you should be mindful of your rights, including the right to remain silent and the right to consult with an attorney before answering or providing admissions. The second key step is to obtain a professional assessment if you have a DUI on your record, or if you fear a possible expansion of grounds of inadmissibility or deportability. An experienced immigration attorney can review your facts, examine the details of your conviction or admission, and explain how the bill, if it becomes law, could affect your status. They may also help identify possible defenses, strategies, or waivers that could mitigate the risk in a given situation. Third, for those who hold a green card and travel internationally for work or family reasons, the decision to travel should be made carefully and after consulting with an attorney who understands your case. If you must travel, you should plan ahead, carry essential documents, and have a plan for how you would re-enter, including how to demonstrate your ties to the United States and how a future change in the law could impact your re-entry. In particular, Understand that leaving the country could create entry challenges if the law changes while you are away, because the acts of entering and re-entering could be scrutinized more closely under a new regime. The fourth step is to consider citizenship as a protective strategy. While citizenship does not provide a guarantee against all forms of removal or denial of status, it does curb many of the potential consequences and makes it much harder for immigration authorities to carry out removal actions. United States citizens are not removable for offenses such as a DUI, generally speaking, and they have a constitutional right to reside in the United States. The path to naturalization requires preparation, time, and money, but it represents a meaningful and durable form of protection that should be explored thoughtfully by anyone who has established a life here. For individuals facing DUI-related charges now, the stakes are particularly high. If a non-citizen is currently facing DUI-related charges, it is essential to coordinate between your criminal defense attorney and a qualified immigration attorney. In many cases, criminal defense strategies that reduce criminal exposure or avoid more serious charges can be designed with immigration implications in mind. A plea agreement that seems favorable from a purely criminal standpoint could be devastating for a person's immigration status if it admitted certain facts or involved a specific charge. An experienced immigration attorney can help protect against those consequences by guiding you through the negotiation process, the factual stipulations, and the potential outcomes. The risk of missteps here is real, and the need for careful counsel cannot be overstated. If you cannot afford an attorney, there are still avenues for support. Legal aid organizations, pro bono programs, and nonprofit immigration clinics exist to provide initial consultations and guidance. They can help you understand the strength of your position and identify resources for representation. The bigger picture matters as well. H.R. 875 is part of a broader trend that legal scholars and practitioners describe as Crimmigration, the blending of criminal law and immigration enforcement into everyday policy. The expansion of deportability grounds, the increasing role of policing data, and the frequency with which minor offenses become triggers for removal together create a landscape that many believe demands careful scrutiny and strong safeguards. The political arithmetic underlying H.R. 875 continues to unfold in public ceremonies, committee hearings, and private discussions among lawmakers. The House has already demonstrated substantial bipartisan support, and while that is not a guarantee of passage, it represents real political energy behind the measure. The Senate will examine the bill in due course, consider possible amendments, weigh the arguments, and decide whether it should advance to a full vote. Advocacy organizations on both sides will issue reports, analyses, and calls to action, and voters may find themselves hearing a wide array of messaging as the bill moves forward. For our viewers and readers, the practical message remains clear. Stay informed, rely on credible sources, and plan for various scenarios. Track the bill's progress on congress.gov by searching for H.R. 875. Keep an eye on committee actions, floor votes, and other developments reported by official portals. Trusted professional organizations like the American Immigration Lawyers Association, major civil rights groups, and established immigration law firms may publish analyses and updates, and of course remain connected with this channel because we aim to deliver timely explanations as events unfold. When significant developments occur, we will bring you clear, fact-based explanations that you can use to make critical decisions for yourself and your family. A final set of reflections focuses on the long-term context. H.R. 875 fits into a historical pattern where immigration policy has increasingly drawn on criminal law ideas to determine who may stay or enter the country. This approach has been described by scholars as Crimmigration, a term that captures a shift toward treating a wider range of conduct as grounds for removal. Those who support more punitive approaches maintain that public safety must come first, that non-citizens have responsibilities to their communities, and that serious offenses should carry serious consequences. Those who oppose the approach warn that the line between punishment and exclusion can become dangerously broad, that there is a real risk of overreach, and that the consequences may fall hardest on people who have already given years of service and love to the United States. The politics surrounding H.R. 875 reflect a broader dynamic in American politics, the desire for tough rules on crime and immigration, alongside concerns about due process, fairness, and the disproportionate impact of enforcement on immigrant communities. The White House has publicly embraced H.R. 875 in principle, signaling executive support for addressing DUI hazards, while leaving open the window for amendments, waivers, or targeted protections that might assuage concerns about fairness and practical implementation. Senators will weigh the evidence, listen to stakeholders, and decide whether this measure is a prudent piece of policy that can be implemented in a fair and humane way, or whether refinements are required to prevent unintended collateral consequences for long-time residents and naturalized citizens who could be caught in the dragnet. The uncertainties are real, and so is the need for steady information. In the meantime, practical steps you can take include building a reliable relationship with a qualified immigration attorney who understands both criminal and immigration law. You should also keep your personal records organized, including all documents related to driving records, any DUI offenses or admissions, transcripts, letters from employers and schools, and any evidence of community involvement or family ties. These materials will be essential if you need to present a case that emphasizes rehabilitation, long residence, or humanitarian considerations. Documentation matters, and the quality of your records can influence the evaluation of risk and the potential effect of any policy change on your status. It is also wise to monitor the status of any required actions, such as license suspensions or probation conditions, because compliance with non-criminal requirements can influence the overall risk assessment in separate but related contexts. It is essential to remember that this discussion is about policy, not prophecy. We cannot predict exactly how H.R. 875 will move, what amendments might be added, or what a future administration might choose to do in terms of enforcement. The legislative process is inherently unpredictable, and a broad spectrum of outcomes remains possible. We can, however, use reliable sources and careful analysis to prepare. We will rely on official sources for the essential facts. For policy details, we should consult the Congressional Research Service summaries, the text of the bill as introduced, and the official portals of the United States Citizenship and Immigration Services and the Department of Homeland Security for definitions of key terms and the scope of protections or restrictions they maintain today. The official source for legislative action is congress.gov, and we will reference it for the latest updates about committee actions, amendments, and votes. The Department of Homeland Security, including agencies such as CBP, ICE, and USCIS, publish guidance and policy updates that can illuminate how current law operates and how proposed changes would be implemented in practice. We also recommend consulting through state and local legal aid networks for those seeking low-cost or no-cost assistance in understanding the implications of this evolving policy. And to keep you informed, we will continue to provide clear explanations, with careful caveats about what changes could mean for you depending on whether you hold permanent resident status, a visa, or other non-citizen status. A critical reminder for viewers: no matter what you hear online or in other media, nothing is guaranteed until a law is enacted and signed by the President. And even then, the actual effect on individual cases may depend on facts and the evolving regulatory framework. As a viewer of this channel, you deserve to know the facts, check credible sources, and plan accordingly, rather than chasing sensational headlines or unverified rumors. In addition, if you are currently facing a legal situation, you should engage a qualified attorney who can review your own unique facts and tell you what to expect. Do not rely on opinions from people who do not have professional credentials in immigration law or criminal law. The interplay between DUI offenses and immigration status is nuanced and frequently changing. The same rationale that leads a policymaker to propose a reform can also be in tension with considerations of fairness and humane treatment. That tension is at the heart of the current debate, and it is why many experts urge caution and careful analysis before drawing conclusions about outcomes. To wrap up, here are the essential, practical messages you can take away today. First, H.R. 875 is not law. It is a bill in the Senate stage that could alter inadmissibility and deportability if enacted, but this is a dynamic process subject to amendment and political negotiation. Second, a single DUI remains a serious offense with potential consequences, but does not automatically erase decades of life under current law, and many cases may still be resolved with careful legal strategy and consideration. Third, if you hold a green card, you should consider citizenship as a strategic option, recognizing that the path to naturalization has its own steps, costs, and waiting times, but offers meaningful protections against deportation in many scenarios. Fourth, for those with existing DUI cases, it is essential to coordinate between criminal and immigration counsel to ensure that plea agreements or factual admissions do not collapse into removal risk and to explore every available defense, exemption, or mitigation. Fifth, if you are considering international travel, consult with a qualified attorney before you depart, because a future change in the law could affect your ability to re-enter. and you may need to present evidence of substantial ties and careful planning when returning. Sixth, commit to staying informed through credible sources and official portals such as Congress.gov, USCIS, CBP, IC, and the White House's statements when they exist, and to sharing information only from reliable authorities with your networks. The world of immigration law is not static. It is a living domain influenced by politics, court decisions, and policy decisions that reflect evolving public priorities. We will cover those developments with careful attention to accuracy and fairness, never sensationalism. The overarching question remains, how should you think about H.R. 875 in the context of your life today? The answer requires nuance, patience, and practical action, not fear. It requires a readiness to adjust plans when laws and policies change, and to seek professional guidance when the stakes are high. That is the real message of this moment. Knowledge, preparation, and prudent decision-making can reduce risk and protect what you have built. Before we finish, a quick reminder about how to stay connected. In the description below this video, you will find references to official sources and guidance from government portals, including USCIS and DHS, as well as links to the Congress.gov page for H.R. 875, so you can review the text, committee actions, and related materials directly. If you are watching on other platforms, the same references apply, and we encourage you to go there for the most up-to-date information. If you find this analysis helpful, please consider liking the video, sharing it with friends or family members who may be navigating similar questions, and subscribing to this channel, Global Immigration Updates, so you will receive timely, reliable coverage as events unfold. We also encourage you to engage with the community in the comments, telling us where you're watching from and what aspects of these developments matter most to you. We will do our best to respond, and your input helps us tailor future reports to address real concerns, real questions, and real situations. In closing, let me leave you with a final reflection. The immigration systems of major countries are always evolving, and the interplay between criminal law, public safety, and immigration status often reveals complex questions about fairness, responsibility, and opportunity. The quality of the decisions people make in moments of uncertainty depends on the strength of the information they have, on the credibility of the sources they turn to, and on the care with which they prepare for potential changes. The more you know, the more you can act with confidence, and the more you can protect the future you have worked so hard to build. As always, this is a channel built on respect for the families and communities we discuss, and it is anchored in a commitment to accuracy, fairness, and helpful guidance, rather than alarm or speculation. Thank you for spending your time with us on Global Immigration Updates. I am David, reminding you that immigration policy can change, and the best safeguard you can have is to stay informed, prepared, and connected with official sources and qualified counsel. Until next time, stay curious, stay calm, and stay focused on your long-term plan, because your future deserves nothing less. If you're watching this from a country outside the United States or from a different legal context, you may notice that the interplay between criminal law and immigration policy has universal lessons about fairness, accountability, and the rule of law. If this discussion has resonated with you in any way, you may want to explore how similar tensions show up in other jurisdictions, and you may find it valuable to compare approaches where they protect public safety while preserving human dignity, and where they may inadvertently create barriers to lawful, productive lives. And if you have specific circumstances or questions that you'd like us to address, please describe them in the comments so we can consider them as part of our ongoing coverage. For families facing this moment, I know that stress and uncertainty can be overwhelming. You are not alone. Our aim is to walk with you through the complexity, translating dense policy into practical realities and offering a steady voice you can trust as events unfold. In the coming weeks, we expect committee hearings, potential amendments, and a robust public conversation about what this bill could mean for neighborhoods, schools, workplaces, and the countless personal stories that define the immigrant experience in America. We will continue to listen, analyze, and report with care, and we will remain vigilant about accuracy, avoiding sensationalism even when emotions run high. It is precisely this combination of empathy, rigor, and practical orientation that helps this channel stay grounded in the realities of everyday life, rather than becoming a vessel for fear or hype. If you have already faced DUI-related questions in your own case, or if you are a student, a professional, a family member of someone who is navigating status issues, your voice matters here. Your comments help shape the kinds of angles we explore and the questions we pursue. We read every note, and we often follow up with deeper dives into topics that communities indicate matter most to them. We want this channel to be a resource you trust, not just a source of information you read once and forget. So again, I invite you to subscribe, to activate notifications, to like and share if this content resonates, and to check the description for direct references to official guidance and resources. There you will find pathways to government portals, to professional associations, and to credible analyses that you can review at your own pace. The path forward for H.R. 875 remains a contest of policy, law, and human impact. It is a reminder that legislation is not a distant thing that exists only in textbooks or on the floor of a Capitol building. It is something that can shape your daily life, your opportunities, and the safety and stability you provide to your family. Our responsibility, as a channel and as viewers, is to approach it with seriousness, to demand accountability from policymakers, and to anchor our decisions in sources that withstand scrutiny. If you walk away with one idea, let it be this: you can be informed, prepared, and resilient in the face of change. You can build a strategy that protects your family while you continue to pursue your dreams in this country. That is the hopeful horizon we aim for, and that is the reason we exist as a community. I will continue to bring you updates that are concise, grounded, and anchored in official information, and I will keep offering practical steps you can implement now to reduce risk and to support your long-term goals. Thank you for watching, for engaging, and for caring about the people who make up the fabric of this nation. This is Global Immigration Updates, and I am David. Remember, immigration policy can change, and the best safeguard you can have is to stay informed, prepared, and connected with official sources and qualified counsel.